Hi, I'm Mitch Simmons. I'm a senior immigration lawyer here at MSM Legal. One of my primary practice areas is in visa cancellations, which means I assist both at the primary level and all the way through to the applications to the tribunal and the courts. What I want to talk about today is that throughout my clients, one of the most common experiences is that they are surprised by the system. The biggest surprise is there's no presumption of innocence. This means that you can be facing visa cancellation before a court even decides if you're guilty or innocent of an offence, or it can mean that you're facing visa cancellation when there is no charge based on an association or on conduct that doesn't even lead to a charge. This is particularly the case for temporary visa holders. So for instance, if you hold a student visa or a visitor visa and you're charged with an offence, the Department of Immigration can move very quickly to consider cancelling your visa. So the way that looks is that, for instance, if you are taken into the police station and charged with an offence but then released on bail, with a court date some months in the future, the Department of Immigration can swoop in and hand you a notice of intention to cancel your visa, and suddenly you're swept up in a world where your visa can be cancelled very quickly. The threshold for visa cancellation when you hold a temporary visa is very low. For instance, under that framework, all the department needs to be satisfied is that you may or might pose a risk to the safety of the community or an individual. And so that leaves a lot of discretion for a case officer to cancel your visa based on very minor conduct. Whilst in those scenarios, the system moves very quickly, we also deal with clients who are struggling with the opposite end of the spectrum where things take too long. That particularly impacts our clients who are permanent visa holders and are facing the cancellation of their visa because they're serving a term of imprisonment and because they've been sentenced to a term of imprisonment for over 12 months. In those cases, their visas are cancelled under a mandatory system, but the practice of the department is they won't take steps to cancel the visa until right before our clients are due to be released either on parole or at the conclusion of their sentence. What that means is that they are taken directly to immigration detention, and it's while they're in immigration detention that they have to then battle this cancellation. What that often means is that clients are stranded in immigration detention for much longer than they were ever required to serve a term of imprisonment for their criminal offences. Another big issue facing our clients in the moment, and it's a hot topic both within the media as well as the courts, is the issue of how the visa cancellation framework works with issues of non-refoulement and protection claims. And so we are constantly battling in the court where there are issues of how these decision makers, whether it be at the department level or the tribunal, deal with whether a client can be sent back to their country of nationality despite a claim or a finding that they will face serious harm in that country. And the associated issue, which is if they're not going to be sent back to their home country, whether they'll be forced to remain in detention indefinitely. One of the main areas that we work in this space is with applications for judicial review in the courts, whether it be the Federal Circuit Court, the Federal Court, all the way up to the High Court. But as immigration lawyers and migration agents, what we can do is, firstly, we can use that experience that we gained through being on the cutting edge of those issues within the court system to help clients at the primary level who haven't yet had their visas cancelled, to apply that knowledge and assist them in avoiding some of the hurdles and the pitfalls so that they don't ever end up in the courts or in immigration detention trying to challenge those more complex issues. The last issue I want to touch on is just the tremendous amount of power the Minister for Immigration has in this area, and that really plays out in two different ways. Firstly, the Minister holds the power to cancel a visa personally, and when the Minister chooses to do that, they don't have to provide a visa holder with the normal natural justice or procedural fairness. What that means is that your visa can be cancelled without any notice and without being given any opportunity to provide evidence or materials as to why your visa shouldn't be cancelled. And so we've had clients who will receive a knock on their door at 6 o'clock in the morning and be taken to Christmas Island because their visa's been cancelled without any notice. The other way this plays out is that, say your visa was cancelled by a case officer in the Department of Immigration, but that you are then successful in getting that decision set aside in the tribunal. If the Minister for Immigration doesn't like that decision, he can then step in and reverse that decision again And once more, that's without any notice or without giving you any opportunity to convince him why that shouldn't be the case.